My father passed away and left the family home to me. As per his will, he has given my stepmother the right to live in the house until she passes on. Unfortunately, the house has fallen now into disrepair. I've been around attempting to fix things, but my stepmother constantly damages the home. Is there any way that I can evict her? I'm afraid that there will be no home left should things be left the way they currently are. So please, can you provide some advice on this?
Chris, I was very scared that you're going to throw that one in my direction because I have slight PTSD because of this particular fact sheet. I think about 6 years ago, I had an eviction with very similar facts, and it ended up being a valid defense to an eviction. So, you know, we very often have cases, and when you see the same facts, it all comes back to you, and you're like, I remember that day in court when I got blasted. So the quick answer, Chris, is potentially no. Habitatio, so for the benefit of our viewers, habitatio is a personal right that you get, which gives you a right of use of a property. So it's a form of a usufruct, but it doesn't mean, usually if you have a usufruct, so you can use the fruits of a thing, it means that you would also be allowed to use that personal right and, for instance, rent the property out. So you can trade with a usufruct in most instances, where habitatio is an exclusive personal right that only attaches to that particular person. Only that person may occupy the property, and the right of occupation is a very strong right in this context, because the person that's allowed to stay in a property then until they pass away, that's a life right to that property. And usually the rule is that kind of a personal right, so habitatio or a life right or a usufruct, has to be registered in the deeds office. The problem with this is, if it's not registered in the deeds office, it doesn't take the right away. It means that when it's not registered, it's an exclusive personal right, meaning that it can't be traded with a third party, and it's not enforceable against a third party. Now, what all this nonsense that I just said means is, if you have a right like that, you can occupy the property and you have the right to do so, which would mean that the child that inherited this property will not have the right to evict the stepmom. This right will always be, even when it's not registered in the deeds office as it should be. Even if it's not registered, it's enforceable inter partes. And what that means is, between the parties that came to this agreement, it will be enforceable even unregistered. But now it gets fun and unfun. It's also enforceable against a third party if it came to the knowledge of that third party. So just to drive my point home, I'll tell you the story about my very unfortunate case 6 years ago. It was a situation where the one brother inherited the house from his parents, and part of the will was the one brother can stay in the house, but the outside cottage must, the brother of the kid that inherited the property, that brother has a life right to the cottage. And so there's a condition in this will that the transfer to the one brother is conditional upon the fact that he must give the other brother a life right. Now, something like that is very easy to prove, because you can simply show the will and you can say, even though this wasn't registered in the deeds office, we can prove that this personal right was created by the will. And the sad situation is the brother that we had to evict was an attorney that was removed from the role. So a particularly clever person that understood what was going on. So he knew about the fact that this habitatio, this personal right, can be enforceable against third parties when it comes to their knowledge. And he was clever because every time an estate agent came by to show the property to other people, potential purchasers, he said, like, how cool is my brother and my parents? I am allowed to stay here for the rest of my life. So we're going to be amazing neighbors, because when you buy the property, I'm just going to stay in this cottage. And eventually, unfortunately, the only solution was actually to subdivide and leave that part of the property, leave the brother in that part of the property. So a very long answer and a sad story to say, unfortunately, you cannot evict your stepmom. That right was created in the will, and unfortunately, even though if it wasn't registered, it is enforceable. But I do want to caution our viewers to not think, because that could be a defense to an eviction, that it will always be successful. Rather, if you do want to do something like that, if you do want to give somebody a right of habitatio or a life right or something, please do it through a conveyancer who will do it properly, who will do a proper agreement, who will register the agreement. Because even though this guy in that particular eviction I did 6 years ago was successful with that defense, it does not mean it's going to work every time. That was a long answer. I'm going to.
It was a good answer. It was a really good answer. Thank you, Cilna. And just, in fact, while you were speaking about this, and I'm reading the question again, it sounds like the story about Cinderella. This is an evil stepmother who has the right of occupation. Yeah, no, let's not get into that.
Wow.
But anyway.
That went so south so quickly.